Have you ever wondered why one veteran gets approved for VA disability while another with the exact same diagnosis gets denied? The answer isn't always the medical condition, sometimes it's the type of claim they file. Today, I'm ranking the 5 most common types of VA disability claims, from the most challenging to the most powerful. If you've ever been denied, this video might help you see another path to the benefits you've earned. I'm Michael Phillips, a Marine veteran and partner at Conquest Law Group. Every week, I review claims from veterans who were told no by the VA. One of the first questions I ask is whether they filed the right type of claim in the first place. Many veterans don't realize there are multiple legal theories for establishing service connection, and choosing the right one can make all the difference. All right, veterans, let's count them down, starting from number 5 on our list. Number 5, aggravation claims. I rank aggravation claims a 6 out of 10. That doesn't mean they're weak claims. It means they can be more difficult to prove because the law requires you to show that military service permanently worsened a condition that existed before you entered the service. For example, maybe you had mild asthma, a knee problem, or a back condition before you enlisted. If military service made that condition significantly worse beyond its natural progression, you may still qualify for compensation. The challenge is that the VA often argues the condition would have progressed the same way regardless of your service. That's why strong medical evidence is especially important. I've seen veterans assume they don't qualify because they had a pre-existing condition. That's not always true. The question isn't whether you had it before service, it's whether your service made it worse. That's why aggravation claims earn a 6 out of 10. Number 4, presumptive condition claims. I rank presumptive condition claims a 7 out of 10. These claims can be incredibly powerful because in certain situations, Congress and the VA have already recognized that specific military service is associated with particular illnesses or exposures. Think about veterans exposed to Agent Orange, burn pits, contaminated water, or other qualifying environmental hazards. If you meet the legal requirements for a presumptive condition, you generally don't have to prove every link in the chain the same way you would with a traditional claim. That doesn't mean approval is automatic. You still need evidence showing that you qualify under the applicable law and that you have the diagnosed condition. Many veterans don't realize new presumptive conditions are added from time to time. If your claim was denied years ago, it's worth checking to see whether the law has changed. That's why I rank presumptive claims a 7 out of 10. Number 3, total disability based on individual unemployability, or TDIU. I rank TDIU an 8 out of 10. This is one of the most misunderstood benefits in the VA system. Many veterans believe they have to be rated at 100% to receive compensation at the 100% payment level. That's simply not always true. If your service-connected disabilities prevent you from maintaining substantially gainful employment, you may qualify for TDIU and receive compensation at the 100% rate, even if your combined scheduler rating is less than 100%. I've spoken with veterans who struggled financially for years because they assumed this benefit didn't apply to them. Once they learned about TDIU, it completely changed the conversation. The key is showing how your service-connected disabilities affect your ability to work, not simply that finding a job is difficult. That's why TDIU earns an 8 out of 10. Number 2, secondary service connection. I rank secondary service connection a 9 out of 10. If there's one opportunity veterans overlook more than almost any other, it's this. A secondary claim is based on the idea that one service-connected disability causes or aggravates another condition. Here's a common example. A veteran injures a knee in service and receives compensation for it. Over time, the altered gait places additional stress on the back and hips. Years later, chronic back pain develops because of the original knee injury. Or maybe chronic pain contributes to depression or anxiety. Those secondary conditions may also qualify for compensation if the medical evidence supports the connection. I've reviewed many claims where veterans were focused on one disability while overlooking several additional conditions that may have been compensable as secondary disabilities. This is why it's so important to look at the whole picture rather than just one diagnosis. That's why secondary service connection a 9 out of 10. Number 1, direct service connection. I rank direct service connection a 10 out of 10. This is the foundation of the VA disability system. Every successful direct service connection claim generally requires three key elements: a current diagnosed disability, evidence of an in-service event, injury, or illness, and competent evidence connecting the two. When those pieces come together, you've built the strongest possible foundation for compensation. Many veterans focus only on proving they served or proving they have a diagnosis. But the VA is looking at the complete legal framework. That's why gathering the right evidence from the very beginning is so important. Even if your claim ultimately involves secondary conditions or other legal theories, direct service connection is often where the journey begins. That's why direct service connection earns my #1 ranking. Let's review today's rankings. Number 5, aggravation claims. Number 4, presumptive condition claims. Number 3, total disability based on individual unemployability or TDIU. Number 2, secondary service connection. And number 1, direct service connection. The biggest takeaway is this: just because one type of claim doesn't fit your situation doesn't mean you don't have another path to benefits. Every veteran's story is different, and the right legal strategy depends on the facts of your case. One of the biggest mistakes I see is veterans assuming that a single denial means they're out of options. Sometimes the issue isn't your disability. Sometimes it's the legal theory used to present your claim. When someone contacts our office after receiving a denial, one of the first things we do is evaluate whether another avenue for service connection may exist. That review alone can uncover opportunities the veteran didn't know were available. I'm Michael Phillips, Marine veteran and partner at Conquest Law Group. If your VA disability claim has been denied, or if you're not sure you filed the strongest type of claim, don't assume that's the end of the road. Every case deserves a careful review. Follow this page for practical information about VA disability and Social Security disability claims. If you'd like our team to review your case, send us a message or visit conquest.law to schedule your free case evaluation. Thank you for your service and thank you for watching. I'll see you in the next episode.